All right, so this talk is going to be in English unless a significant number of people object. That doesn't seem to be the case. All right, so I'm going to talk about the Radio Lockdown Directive. My name is Sebastian, and I work for the member of the European Parliament, Julia Reda. And we've been working on the, well, what it's called the Radio Equipment Directive for the past 2 years. So in summer 2015, we noticed that Freifunk and other community Wi-Fi projects might be threatened, actually. In August or September 2015, the FCC published a public consultation which mentioned the DDWRT project as an example of firmware projects that might change the radio parameters of radio equipment, and the FCC wanted to well, basically ensure that radio parameters weren't changed beyond what's allowed within the permissible frame of radio. I don't know, that kind of technical stuff. So. In turn, the European projects noticed, because of the DDWRT case in the US, that the EU actually has a similar provision. And that is what we call the Radio Equipment Directive, or what is called the Radio Equipment Directive. Yeah, and it has this wonderful provision that says, basically, radio equipment needs to ensure that you can only install software onto it for which the compliance with the, well, the compliance has been demonstrated. So any kind of combination of hardware and software needs to have a prior approval by the manufacturer. There is a recital which says that this shouldn't prevent the use with different software, with third-party software, but there is kind of a dichotomy between these two. On the one hand, they need to ensure that they only have software installable that is compliant. On the other hand, they need to ensure that third-party software can be installed. Effectively, that means that manufacturers will have to lock down their devices. Technically, the only way that I can imagine how this would work is by implementing cryptographic masks in the hardware that only allows cryptographically signed software to run on the chip. That is something that we know from PCs, where we have TP modules, trusted platform modules, that ensure with a mechanism called secure boot that only operating systems that have a certain cryptographic signature can run on the hardware. So effectively, this would affect open source firmware projects, and through them, community Wi-Fi projects, because Freifunk and others they install their own customized software onto these hardware, onto this market grade hardware. That also means that radio amateurs who want to change radio parameters through software are affected through this provision, even though they are explicitly exempt from the Radio Equipment Directive in one of the annexes. Of course, they also rely on cheap market-grade hardware that they can modify, and well, if this market-grade hardware doesn't allow this modification anymore, they are also impacted. The same goes for education and research. There are several Wi-Fi projects at universities that wouldn't be able to run their customized software anymore. Yeah, well, and that goes for educational projects such as your hackerspaces as well. It also goes for internet service providers. There was an open letter from the Internet Service Providers Austria, Internet Service Providers Association Austria, to the Austrian government that said this would be a distortion of their market, because they wouldn't be able to install their customized firmware onto routers anymore. We have been contacted by small and medium electronic producers that say that their embedded hardware, for example, that is also radio equipment, wouldn't be possible anymore because they also rely on cheap market-grade hardware that they then modify using software and that they then sell on to third parties. Well, and also, of course, the original equipment manufacturer is impacted because they have to ensure that only software that has been proven compliant is installable on the software. So they will have to implement into their hardware these mechanisms. And I've been told that with a chip that maybe costs a couple of cents in production, gives you a couple of cents in earnings, it would reduce their earnings massively by adding this additional feature or this additional feature set to their hardware. So what can we expect? We can expect that the updates will only be installable anymore if the manufacturer consents to them. So if they, after 2 years' time or so, decide that they don't want to provide any updates anymore for their firmware, you can't replace it with an open source firmware anymore because you would have to have it signed by the manufacturer. That, of course, impacts the overall security and stability of our common internet infrastructure. As we've seen a couple of months ago when the DIN DNS network was attacked by what I read was mostly apparently Wi-Fi routers that had a vulnerability that was used. And that is kind of this whole combination of how does security work and how do updates impact security and the overall network infrastructure is kind of hard to explain to engineers that don't usually work with software. So yeah. There's also no incentive for manufacturers to allow third parties to be installed on their hardware because they would have to check each and every software that somebody sends to them, and that costs them, of course, costs them money and time. Yeah, I already said cheap market-grade hardware would probably become scarce, impacting Freifunk, radio amateurs, research and education, and effectively hackers. So we've been putting out a call not to endanger community Wi-Fi networks. In 2015, it's already a bit of a time ago, but in 2015, as you might well remember, the Freifunk and other community Wi-Fis were very successful providing Wi-Fi access, internet access to refugees in Germany and beyond. And so endangering community Wi-Fis has immediately an impact on society as well. The current state is that the Commission has put into place an expert group that is supposed to inform the Commission as to which classes and categories of equipment should be concerned by the provision that I mentioned before. The 33i is what its number is. This expert group has met in October. There's a question there. You might want to take a microphone.
Just for clarification, is this provision already in place, or is it planned to be in place at some point?
It's unfortunately already in place.
Okay, thank you.
Yeah.
I wasn't sure if I understood correctly.
Well, okay, let me take a step back there. It is not in place because we're still waiting for this definition of classes and categories of equipment that will be affected by the provision. So until we have the expert group finished and all that that follows the expert group, it is not enforced yet. It is in law, but it's not enforced yet. So yeah, this expert, thanks for the question, because apparently that wasn't clear. The expert group is supposed to inform the Commission as to which equipment to subject to this provision. and that work isn't done yet. So they have met twice, in October and in November. They're going to meet in February again, and probably another fourth time. And then we're still not there yet, because then the Commission will have to draft what is called a delegated act, which contains these classes and categories of equipment. And that might as well take from, well, if the expert group finishes in time, from the end of next year to maybe 2020, because we're going into an election year in 2019. You'll have a European election in 2019. That also means that the European Commission will be replaced by a new Commission, possibly, and therefore they might as well carry it over into 2020. However, there will be a new impact assessment after the expert group has finished working. So there will be an assessment of how the definition of classes of equipment will affect the market. Waiting for the cheers. How they will affect the market, how they will affect producers, but also consumers. And then there's going to be a public consultation. That as well is something that you can take part in. So we will need your input for that public consultation, but you'll have to be patient probably until 2020, until it's there. Oh, I had a typo there. So to Freifunk, please keep up the good work. Freifunk has a really good reputation in Germany, and I think the same goes for Wi-Fi networks such as Gifi. What's his name? Presented an hour ago or 2 hours ago. Pau presented 2 hours ago about the mesh network that they've built up as a community network in Catalonia. So there are lots of good relations with public authority already. There is lots of good contact there. So keep up that work. Keep contacting your local representatives. Keep being very vocal to support Freifunk. Also, join forces at the European level. It's highly important that you follow the developments on the European level, because even though everything later on might be or will be implemented in your member states, it's very important to keep track of how the development goes before it's implemented in your member states, because then really there's not a lot of things to do anymore and to change anymore. You need to impact the European developments. There are a couple of different possibilities. Either you become a member association of a bigger association or of a European association. CCC, for example, as a German association, is a member of EDRI, European Digital Rights, who are basically advocating for digital rights in Brussels. So that might be a possibility. I know that there have been contacts there from Freifunk, but I don't know where that led to. But if you represent another association, please think about being a member of them, or joining forces on the European level and becoming an association yourselves. Because I think it's really highly important, if it's only to apply to these kind of expert groups, because the Commission only allows representative bodies to join these expert groups. So, speaking of which, support the experts that are already in the expert group. We have two super good colleagues from the Alexander von Humboldt Institute for Internet Society, as well as the International Amateur Radio Union, and other allies that are in there. They need to produce documents over and over. They need to produce input to this expert group, and they can use a lot of input from and help from outside. There is a mailing list that you can sign up to. Yeah, you can support them, and you should. And then I guess, again, it's a bit of a stretch, of course. Maybe it's only going to be in 2020, maybe it's going to be next year, but please participate in the public consultation. We need to make the voice of community Wi-Fi heard in the public consultation once the expert group has finished working. That's it from my side. Questions? I guess we had so excellent questions in between my talk that there are no more questions now.
So in case this regulation is put into force, will there be some, let's say, legal constraints against breaching of such encryption or whatsoever? So will it be some kind of let's say official crime, or I don't know what's the exact term, but despite of the fact that you manage to put a different software in, is then cracking this software some kind of official thing which an attorney general will put call?
So the directive was already agreed on in 2014. It had then a period until it entered into force in 2016. So we're already right in the middle of the application of the directive, only that the 3.3i part that we've been talking about isn't effectively made active yet because the class definitions aren't there yet. However, it's not so much about you probably circumventing or I don't know whatting the trusted platform or whatever might be implemented in this hardware. So it's not about hacking these devices, but if a manufacturer doesn't put in place these mechanisms thoroughly, then they would be in violation of the compliance requirements. So it's not. Is that
so in case there is a hacker community which is able to put a different firmware in, it would be the job of the manufacturer to optimize the process to make it more secure. Otherwise, he might find himself in a position where he is held liable for this.
I guess a manufacturer would only be held liable if you could say that their measure wasn't effective or was. What's the English term for?
At the moment there are a lot of, for instance, for TP-Link, there are a lot of firmwares with crypt loaders. It's with Ubiquiti starting as well. So there are in most cases possibilities to generate loaders which circumvent the crypt loader and then to load regular firmware. But on the other hand, there are cases like perhaps you know this TP-Link EAP245 where TP-Link totally blocks all requests for firmware or access to it. I think the official answer of TP-Link was something like yes, we are allowed to tell you how to circumvent it, but we are not forced to do it, and we don't.
Okay.
So you may flash a different firmware, and but we don't tell you why. And so as people found out for this product, especially, it doesn't help to use the serial console, and even dumping the flash doesn't help. So there is really a hard TPM in this product.
Well, so coming back to this, where's my mouse there? To this recital 19. Where's my window? So this is the original text from the directive, where recital 19 says that where these technical measures are used to verify the compliance of the combination of software and hardware, they may not be abused to prevent its use with software provided by independent parties. So they cannot use these DRM, TP measures to block you out of installing software onto these devices. as far as I'm concerned, and looking into the US, where the FCC has fined TP-Link for removing part of their firmware where you could upload update images. I think it also means in the European directive that manufacturers would have to make sure that software can still be installed, even if it's provided by a third party. So I guess the router that you've been mentioning, I think, would be in violation of this recital. Now, a recital is more of an explanatory addendum to a directive. So it could be used in a court case, but it's not part of the law.
Okay, a different question. What do you think about the market moving to hard Mac products more and more? So where you have let's say, Wi-Fi baseband embedded in hardware, so where you don't have any access to the software side of it, and of course you have just some AP layer to access, but you don't have the full control like in previous drivers like we have in the Atheros.
I guess for community Wi-Fi projects, those wouldn't be as much of a problem.
Yeah, no, but because we rely on some protocols which are not good supported, like 11S or ad hoc modi, and if those don't work fine, of course the open source drivers were able to fix a lot of stuff, and if you don't have this layer in access, you're blocked out. You have some driver. It's a bit like with the graphic cards on Linux PCs, where you have some open source drivers which are so crappy that you don't want to use it.
I'm going to come back to, on the one hand, it's a security hazard. If you have this hardware where you cannot modify a certain part of the hardware anymore, then there might be vulnerabilities or imperfections in hardware that you can't change anymore. So basically, you'll have to throw away the device after a vulnerability has been found that you cannot fix. When it comes, well, I guess the political argument to make would be that is one thing that we don't want to achieve by this directive. So we don't want to threaten the overall security of the internet through such measures. We don't want to impact parties such as the radio amateurs and research, which also wouldn't be able to modify radio parameters then anymore. So yeah, but it's a bit of a political argument.
And we don't want electronic waste.
Sorry?
We don't want electronic waste.
Precisely. And I think third-party firmware is a perfect example of prolonging the life of your devices.
Hi, thank you very much. You mentioned the two allies in the expert working group, and I was wondering whether their participation is the result of your call to action, and whether their attention to the directive raised thanks to you, and do you know if they had taken part in other expert groups at the level of the EU Commission before?
Well, I'm quite happy that the radio amateurs actually applied for the expert group after we called to action at FOSDEM, for example, last year. Actually, the year before, because the application timeframe was just before FOSDEM. It was over Congress, basically, for a month. But anyways, they applied, and very fortunately, they were taken into account. The Humboldt Institute for Internet and Society, I didn't know about them. We're very happy to have them. I've been speaking with the colleague who I'm very happy to have met, and who I'm very happy that he's there. But there are some allies beyond that are part of the expert group that we are in good contact with, and that is not only me or our office, but also like they're on the mailing list. So have they been on expert groups before? Not that I know of for the first two, but the ally that we have, he gave regular input on security matters to expert groups. So he's basically a contributor to the European standardization body ETSI.
a quick follow-up because as you stressed, the consultation that will be held will be very important. And one thing that might be interesting to do next year when the consultation is up and running is to reach out to a mailing list that was set up after an open letter was sent to the EU Parliament in March, asking. There were a few demands regarding the regulatory needs of community networks in Europe, and so we have a mailing list with all the 30 signatories, and which are community networks, and almost 100 other organizations. And so it might be interesting to relay the information and the fact that the consultation is up and running to them when relevant.
Definitely. So yeah, I can only encourage you to join the mailing list. And yeah, unless there are some more questions, thank you for being here. Thank you for your question.